And do you recall my ruling saying that you were to leave the home with that boyfriend? Do you recall that?
No, Your Honor, I don't.
Hearing where the issue was you were moving from place to place and taking your children with you. Do you recall that? One of the complaints was that you were testing positive for marijuana. Do you recall that?
Yeah.
And do you recall that your CPS caseworkers had no idea that you were testing positive for marijuana in this court? Do you recall that?
One judge, one morning, 5 different lives on the line. A mother who vanished from probation for over a year and a half. A woman on probation for manslaughter caught with drugs and running from police. A defendant with 2 violent cases just weeks apart. And a woman on probation for armed robbery given one last choice: get help or go to prison. This is what real accountability looks like in a Texas courtroom.
2022 CR 0841C State versus Kayla Connor. Can I have parties announced for the record? For the state?
Ashley Jones for the state.
For the defense?
Roberto Ambrosino.
And are you Kayla Connor?
Yes, ma'am.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney? Did you understand it?
Yes.
Are you the same Kayla? Is it Janine Connor, who was placed on deferred adjudication in 2022 CR 0841C for the offense of injury on August 25th, 2022 for a period of 5 years? Is that you?
Yes.
All right, state.
Yes, sir. Your Honor, the state is alleging from the state's motion to supplement pending motion to enter adjudication of guilt that the defendant violated condition number 4 in Bexar County, Texas. The defendant, Kayla Jan Connor, did then and there fail to report to the supervision officer as directed for the months of March, April, May, June, July, August, September, October, November, and December of 2023, and January, February, March, April, May, June, all the way through December of 2024 in violation of condition number 4.
Right, to that allegation, how do you plead? True or not true?
True.
And state, with the regards to the other allegation?
The state will waive the other allegation.
No
Any objection? All right. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is not a proposed agreement. The state will argue for our recommendation and I plead.
All right. State, what are you requesting?
Your Honor, given that the defendant has not reported for over a year and a half now, and given her history and not only the facts of the case, that state is going to ask for 2 years in the Texas Department of Corrections.
All right. In defense, what are you requesting?
Judge, I'm requesting that the court impose some type of jail sanction, revoke her deferred adjudication, adjudicate her, and put her on straight probation. Or possibly, I saw there was a recommendation from probation that their recommendation was to extend and assign her to safety. I think her only positives were for THC. I don't know that that would be a good fit. I think maybe SATIF might be a better fit under the circumstances. And I did have a witness.
All right. Do we call your witness?
Carmen Rodriguez.
Ms. Connor.
Oh, come forward. Thank you. Hello. All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand. State your name for the record.
Carmen Dolores Rodriguez Mills.
And good morning, Ms. Rodriguez. How long have you known Kayla Connor?
I believe the first time I met her was around 2014, right before my husband got orders to station at Scott.
Okay, and she's essentially friends with your daughter, correct?
Correct, that's how I met her.
Okay, and so you've known Kayla for a while. What type of family life did she have as long as you've known her?
It wasn't easy. When I met her, she was living with her grandmother because she had her parents weren't really in the picture. And when we left and came back, we started talking to her again last year. And that's when we find out that everything that had happened, and she was not in a good relationship and she was trying to get away from that person. So her and my daughter had gotten contact again, but it wasn't a good example.
So she has had a hard life, as such. And with respect to her probation, I guess you were recently made aware that she had a warrant for essentially not reporting to probation.
Yes, I probably around, I want to say around New Year's, she let it be known. And at that time, I was trying to talk to her, and I don't know what the process would be. So I was trying to convince her if we could hire a lawyer to explain what needed to be done.
And so once you were made aware of her situation, you would advise her to deal with the warrant, turn herself in some form of fashion.
Well, yeah, whatever I don't know if she would have had to go to the probation or who.
Okay. And do you feel like you've been a positive influence in her life to this point?
I feel yes.
Okay. And has she essentially spent a lot of time at your house over the last few months?
Yes.
Okay. Has she lived there or just
Sometimes my husband and I joke that she lives there. Yes.
Okay. Okay. And if the judge were to continue her on probation in some form or fashion, would you allow her to live with you, at least in the short term, while she gets back on her feet?
Yes. As long as she abides by the rules.
Okay. And based on what you've seen, do you think that'll be a problem?
No, I don't think so. I just think she needs the guidance.
Okay. Do you think there's good in Kayla?
Yeah.
Do you think the judge should give Kayla another chance?
Yeah. I know she's screwed up, but
Do you think that maybe Kayla lacks some structure and support that maybe she didn't get growing up, and maybe you could provide that for her?
Yes.
Help provide that for her to some extent?
Yeah.
Okay. Thank you. I'll pass once.
All right, any questions?
What's your daughter's name?
Michelle
Michelle, last name?
Rodriguez.
And how long did you say you've known Kayla?
I think it was around 2014 because we left in 2015. And then, so I knew her then because I had to get permission for my daughter to go over there. And we talked to the parents before.
So 2014 to 2015, you knew her before you left?
Yeah, before we left. And then when we came back, I would say it was last year that she started coming back.
When did you come?
Well, I came back, my dad had cancer, so we came back in 2018. But my daughter was in Clovis.
Okay, so from 2015 to last year, you really haven't had any interaction with Kayla?
Personally, no. Just my daughter saying, oh, I talked to her. Or, yeah.
Those are the only questions.
Any further
No,
questions?
Your Honor.
I have a couple if no one has any objections.
No objection.
So you mentioned that she was in a bad relationship.
Yes, ma'am.
Was that the relationship she was in while she was on probation?
Yes, ma'am.
Okay. And did she ever discuss with you that Child Protective Services was in her life?
Child Protective Service. Well, she told me about the case and that she had certain requirements she was supposed to be making.
All right. And did she tell you her requirements with Child Protective Services?
I didn't ask specifics.
All right.
I was just kind of trying to get her to get back on track with the probation.
Thank you so much for coming down. I appreciate your coming down.
Thank you.
All right. Any other witnesses?
Just briefly call my client.
All right. Can you raise your right hand for me? Do you solemnly swear or affirm that the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Kayla Connor.
All right, you may proceed.
Good morning, Caleb. You heard the testimony of Carmen Rodriguez. If the judge were to continue you on probation, are you in agreement to reside with Carmen in the next few months while you would get on your feet?
Yes.
You heard mention of a bad domestic violence involved relationship that you had been in previously. Has that ended?
Yes.
Okay, when did that end?
About May of last year.
So May of 2024.
Yes.
So that was kind of during this period of time that you had a warrant of
Yes.
arrest, essentially. Why should the judge give you another chance on probation?
I'm in a better place than I was when all of this happened. I understand that I messed up. I did not go about it the right way, but I'm out of that relationship and that situation that I was in. And I know now that I have the support team that I do have, I am capable and more confident in myself now that I can get this done.
And why didn't you deal with the warrant earlier?
Honestly, I was scared. I've never been in trouble before.
So that's the first criminal case you've ever
Yes.
had.
So I really had no idea how it was going to go. And due to being a mother of 4 kids, I just didn't want to do time away from them. That's really all it is.
Okay. And essentially, I wasn't on that case previously, but based on what you told me, you were given a period of time that you needed to provide residence in Bexar County.
Yes.
And you told me that you did get residence in Bexar County, but you were late in providing notice, and that's when the warrant went.
Yes.
And so that went out quite some time ago, but after that, you didn't deal with it because you had the warrant and you were scared.
Yes.
If the judge were to continue you, who's to say the same thing wouldn't happen?
Like I said, I'm confident that I'm not going to slip up. I'm out of the situation that I was in, and that was a very big factor as to why things went the way that they did. And now I'm working on myself and my future for myself and for my kids.
And you have minor children, correct?
Yes.
How many children do you have?
4.
4, and what are their ages?
5. My twin boys are 4, and my youngest is 2.
Okay. And where are they with?
They live with their father.
Okay. And does he have like primary custody essentially?
There's nothing really in place. It was just a verbal agreement due to the fact that I had the warrant. I thought it would be best that they lived with him until I was able to get it figured out.
Okay. And so you voluntarily did that
Yes.
on your own? Okay. Is there anything else you want the judge to know why she should consider continuing you on probation?
All I have to say is that if you give me another opportunity, I won't make you regret it.
All right, any questions, State?
Ms. Connor, what is the father of your children's name?
Nicholas Treadwell?
I'm understanding that you were given a gift by being placed on probation in the first place for this case.
Yes.
And then you understand that you messed up that probation by not doing the things you were supposed to do.
Yes.
And then the judge gave you an opportunity to come back and continue to do what you were supposed to do. You didn't. And then you didn't report for over a year and a half. Is that correct? That's right.
I have some questions if there are no objections.
No objection.
All right. So this relationship that you were in, that the previous witness says was not a good relationship, was that the relationship with the boyfriend who was supposedly working at Toyota? Or was this some new person? Or, oh, you say Tesla?
Yeah, it's Tesla.
All right. So that was him?
Yes.
All right. So do you recall being here for a compliance hearing? And at that compliance hearing, there were 2 CPS caseworkers. Do you recall that?
Yes.
And do you recall that nobody knew where you were living because you would move from place to place? Did you recall that? Do you recall that?
Honestly, no. I was in touch with my probation officer.
Now, I want you to listen to my question. Do you recall the compliance hearing where the issue was you were moving from place to place and taking your children with you? Do you recall that?
Yeah, I believe so, yes.
Do you recall coming in where the caseworkers, one was by Zoom, well, actually, both of them were by Zoom. And do you recall coming in and one of the complaints was that you were testing positive for marijuana? Do you recall that?
Yeah.
And do you recall that your CPS caseworkers had no idea that you were testing positive for marijuana in this court? Do you recall that?
Yes.
And do you recall my ruling saying that you were to leave the home with that boyfriend? Do you recall that?
No, Your Honor, I don't.
Okay. All right. I have no further questions.
Any questions, Your Honor?
All right. Any other witnesses?
No, Your Honor.
All right. And I've heard both your arguments and what you're requesting. This is what the court is going to do. The court is finding violation of condition number 4 true. Court is going to find you guilty. The court is going to grant the motion. The court is going to sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Did you understand that and sign it?
Yes.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Because this is an affirmative finding of family violence, you're also not allowed to own or possess any weapons or ammunition. Good luck to you. 2020 CR 4098A, State of Texas versus Brianna Renee Mitchell. Can I have parties announced for the record for the state?
Brittany Sparks.
Defense?
The attorney record, Monica Guerrero. I'm covering for Ms. Guerrero. Joseph Stateson. Ms. Mitchell, would you give this judge permission for me to do the plea in case of Monica Guerrero?
That's right.
All right, I'm gonna need you to speak up, okay?
Yes.
All right, are you Brianna Mitchell?
Yes, ma'am.
All right, I'm showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Brianna Renee Mitchell who was placed on community supervision in 2020 CR 4098A for the offense of manslaughter on December 10th, 2021 for a term of 10 years? Is that you?
Yes.
All right, state.
Yes, Judge, violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of possession of controlled substance, penalty group 1, in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of fail to ID fugitive intent to give false information in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 1 on or about the 8th day of September 2022 in Bexar County, Texas. The defendant, Brianna Renee Mitchell, committed the offense of evade arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True.
We'll waive the other violations.
Any objections to the state's waivers?
None.
All right. Did you understand by pleading true to violations 1, 1, and 1, the court could find it true, grant the motion, and sentence you up to 10 years in prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1, 1, and 1?
Yes.
The court will find 1, 1, and 1 true. Is there an agreement?
Yes, Judge, we're asking that you grant the motion, revoke her probation, and sentence her to 10 years in TDC. In addition, Judge, will be taking into consideration cause numbers 2022 CR 10345B, County Court cause number 692652, County Court cause number 692653.
Is that the agreement, defense?
It is, Your Honor, and I believe I may have made a clerical typo on the certificate of appeal. I may have put the I may have put the KSB in TIC instead of the NPR. That's my mistake.
Yes. Yeah, I'll correct that. Is there any objections to the court correcting that with the proper cause number?
No, from the defense.
No.
And if I may put something else in the record, Your Honor.
Yes.
This offense was created during a time where Ms. Mitchell was on federal release, supervised release. She has federal back time, and post the offense, she did time in federal prison. I have some dates if I could put those on the record.
Yes.
She was in custody in federal prison or federal custody on April 18th, 2016, where she was sentenced November 17th, 2016. And she was not released until April 3rd, 2020. When she was released April 3rd, 2020, it was supervised release. And there was a revocation hearing. And she has federal custody time from February 18th, 2022 to April 13th, 2022. And we ask that she be given credit for federal time in addition to the Barry County time.
So you're asking for credit from April 18, 2016 to April 13, 2020?
We are, and I did explain to my client that is prior to the offense date, but she was still in custody post that also, and that it's the court's discretion to award time.
So with regards to the dates from April 18, 2016 to April 13, 2020, was this case open on a motion to revoke or no?
I don't believe it was on a motion to revoke.
All right. Was this case pending?
I have to.
Right.
I can
So-
check one moment, Your Honor.
Okay. So that's what I want to know about that. But with regards to the February 18 to 2020, February 18, 2022 to April 13, 2022, this was pending, correct?
Yes.
All right. So she will definitely receive credit for those dates. I just need to check on the April 18th date. Well, it appears, Ms. Sparks,
Yes, Judge.
on this case, I'm being informed by the clerk that this case was actually on the system January 2nd, 2016.
Yes, Judge, that's what our computer shows.
Okay. So we can go back on the record, Brenna. So are you asking the court to follow this agreement?
Yes.
Are you waiving your right to appeal?
Yes, ma'am.
All right. Then the court is finding 1 and 1 true. The court will follow your agreement, revoke, sentence you to 10 years in the prison, take in consideration 2022 CR 10345B, County Court Cause number 692-652, 692-653, give you credit for any time served, and the court will give you the credit served in federal custody from April 18, 2016 to April 3rd, 2020, and February 18, 2022 to April 13, 2022. Is there anything else from either side with regards to sentencing?
No, Judge.
Nothing from defense.
All right. For some reason, there's no affirmative finding on this of a
On the
deadly
original?
weapon. Yes. Let me see something. Just one moment. I don't know what the underlying facts of this case were. Just give me 1 second. I'm assuming a weapon was involved, be it a vehicle or something else. All right. Yeah, it's involved a gun.
It appears that my client appears that it was with the co-defendant who had a gun. Her client didn't have a gun, but that was not negotiated with the district attorney's office with Marcus prior to this.
All right, because I mean, according to the, and I know this is before your time, Mr. Statesman, but according to the indictment, it says that Brianna Mitchell did recklessly cause the death of an individual, namely, the complainant by discharging a deadly weapon. So this is pre this attorney, Ms. Mitchell, but that's what's in the paperwork. So there's going to be an affirmative finding. So there's an affirmative finding of a deadly weapon. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck. We can go off the record. I saw in this case where parenting classes were ordered for you. So here's the thing. Someone else is taking care of your children or your child. When you are released from prison, and at some point you will be, do not go up to the house acting as though, here I am, let me put my rules in place and disregard whatever rules have been set for your children. You understand? You're going to have to humble yourself. Court is calling 2022 CR 0499, State of Texas versus Kayla White. Can I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Surgery bar from this point.
And are you Miss White? Right, the defendant entered a plea on July 12th, and she applied for deferred adjudication. According to the plea bargain agreement, punishments be assessed at 5 years in the prison. There's a $1,500 fine. The state is remaining silent on the application, and they're taking in consideration 2022 CR 0814D. There's an affirmative finding of family violence and no contact with Alexander White and Kayla Connor. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, ma'am.
Any objections? State?
From the state.
Defense?
No, no, no.
All right, the state is silent on the application. Is there anything you wish to say on behalf of your client?
Yes, ma'am. Thanks. From the very beginning of our representation, Ms. White has been probably one of the most diligent clients as far as keeping up with her case, with her settings, coming to see me, talking about it. And I would say from the very beginning, just our I guess plan for this case was about taking responsibility and doing everything she could to report that she would be a good candidate. She has gathered, and sometimes it's hard to wrangle a bunch of people to do letters of support, but she has gathered 6 letters of support that we have. I had not filed them with the court judge. I have them here, and I wanted to let you know and spoke about her. But if the court would like to see them, the state has had an opportunity to look into their comment. That way, then you work out something in the two.
All right, any objection to the state viewing the letters? I'm sorry, to the court reviewing the letters.
No objection.
What I'm interested in, even though the state is taken in consideration, and I look at everything as a whole, is that she had an injury on June 22nd, and it is assault on July 15th. Now, understand that assault is involving her niece, and her niece, you know, I guess she did an affidavit of non-prosecution. She doesn't want to be a part of it. She thinks that she shouldn't be even on probation for this. So I understand that. So we're going to put that to the side for a minute. I want to know what is happening with this injury. Is that about?
To be very general about it, Judge, there were quite a few people during the pandemic that were living in an apartment, a single apartment. The primary case, without getting too deeply into any conjecture or anything like that.
Yeah, and honestly, with regards to the injury to the child, you know, if people want to say allegedly, I'm fine with everything you're about to say. I'll put allegedly in my mind in front of it, but I want to know what's going on with that so I can make a decision on whether or not I should grant her application.
Yes, ma'am. So my understanding is that the child is actually the son of an individual living in that apartment, named Brandon White. I believe he has taken a plea on this case and is currently serving for this. Ms. White was residing in that apartment with her husband at the time. They had kind of a separate area. The way that the apartment set up, they were living in a separate area. During this period of time, I don't know that this is, I believe there would be several witnesses that can attest to this, that she worked these long shifts during that period of time. They pretty much spent all of her time, or the significant amount of her time there at these shifts. They didn't have a whole lot of interaction with the victim, if you will, in this particular case. However, her name was mentioned in the interview done of the victim. And so that's, I believe, just having the fact that these people were all in this apartment that resulted in these charges.
All right. Do you have any objection to the state telling you what's in their file?
No objection, Judge. Obviously, this is for factual purposes.
All right. I'm putting it allegedly in front of everything in my mind. State, can you tell me about the injury to?
Yeah, Judge, just to give me a minute to refresh my memory. I'm sifting from Michael, but
Okay.
and it's some being taken into consideration. The defendant was indicted on that one, count one, for striking the victim with a paddle, striking with a belt, striking with a hand, and then count two by omission, causing bodily injury, because she assumed clear custody and control of Alexander White.
And I don't know if both of you all want to step back and address what's in the police report and then come back up.
Okay.
Yes. So if defense and state, if you can look over that, so it can help me make a decision on her application.
Okay.
All right.
Just to confer about what's in it, to address the court.
Yes.
Okay.
So we are back on the record. Ms. White, if you can come forward. And again, I'm taking this as allegedly. All right.
And
Yes.
Judge, the child in this case was taken to the hospital, and there were several co-defendants. But he did make allegations that the defendant in this case spanked him, hit him with a paddle, hit him on his chin. She admitted to spanking him. She said she got the paddle as a deterrent, but had never used it on him. She also admitted to spanking him with a belt 3 or 4 times. So there are admissions that she did cause an injury, and the child himself did say that she caused an injury as well.
All right. And again, I'm putting allegedly before my mind in my mind. But is there, do you want to call your client as a witness to address these issues?
I can address them, Judge, unless the court
It may be best for her because Ms. White, what I'm looking at, and I know the state is taking it in consideration, but I have technically before me 2 violent offenses. One is the injury to that was alleged to have been committed on June 22nd, 2021. And then a month later, we have this assault choking from July 15th, 2022. And so I'm trying to figure out whether or not I should grant your application. And I need more information that's not in the PSI report. So if you raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, defense, do you have questions?
Yes. So, Kayla, if you could just explain, the prosecutor just had an opportunity to kind of focus in the company, and I know that you did want to get some conclusion. So we can address the court regarding especially with this.
So during the time that Raymond was dating my niece here on the case, he called both of us Aunt Kayla. He did not discern between which Aunt Kayla's. Raymond never discerned that it was his girlfriend to his child. And I had to explain to him, I said, do you understand that you were basically dating your step niece and you have to explain like this all to your child? We went through that bundle. We explained to Brandon and Kayla that since they decided to date each other instead of taking care of what they needed to for their own children, we were going to step back and stop as far as we would help them with a place to stay until our lease ended. And after that, we were rendering no more help to them. The last time I had spanked Alexander had been in December of the year prior. And after that, I had spoken with Brandon and he said that he had checked because when I did spank him, Alexander had moved and jerked. And so when he did that, I stopped. I told Brandon, I said, look, since he's moving, he's jerking, I will not spank him any longer. I won't recommend you. You need to be the one to do this. You're his dad. You need to be the one that steps up. And
Real quick, and just talk about what was said. You explain, did you ever strike Alexander?
this, I never struck him with the paddle. I spanked him once with my hand, once with the belt, and I never spanked him again because he jerked both times. And my last thing was I didn't want to injure him.
And so,
It was your best.
and so as you heard that Judge Boyd is talking about the fact that there's a few different cases in a certain period of time. And so I know that you've had an opportunity during the PSI interview, judges have been to give that. But regarding that specific instance, it was involving a kid. Okay. And so if you could just explain to the judge briefly what transpired.
I asked Kayla to wash the dishes that have been similar to several.
Okay, and just so both parties know, I've read the PSI report.
Very good, Judge.
Yes.
Okay, just want to make sure.
No. I always read the PSI report with a fine-tooth comb, and I've read all the police reports.
And I didn't want to be too redundant, Your Honor. I apologize.
Oh, no problem. I know, just so everybody knows, everything that's put in front of me, I always read it. Like every single line, every comma, every semicolon, I always read it. So, I still have concerns with the injury to the case, even though it's being taken in consideration in this case. And the state is silent, but I think we need to reset this and state, if you can explain to me or have someone explain to me why that case is being taken in consideration. I don't know. Maybe it wasn't provable. I don't know. Maybe there's some other reason or some information that they have that I don't have access to, because I don't know anything about that case other than what the charge is. And I'm just a little bit concerned that we have two violent offenses so close together. So, state, will Mr. Villarreal be here tomorrow?
Yeah, Judge, he should be here tomorrow.
Okay. All right.
And Your Honor, if there was a specific time that the court wanted here, I know that, and this is just me asking on her.
Oh, no.
I know that she does work tomorrow, and I know that this is more important.
When is your next off day?
The next off day would be Wednesday.
All right. Norma, are we able to fit this in here Wednesday or next week? So let's just do a Wednesday at 9. Everyone needs to be here exactly at 9 a.m.
Very good.
Okay. All right. So we're back here for sentencing. The defendant had applied for deferred adjudication. The court, because it wasn't noted on the docketing sheet, the court reviewed the stipulations and found there was sufficient evidence to find her guilty, but deferred finding of guilt. According to the plea bargaining agreement, punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. State is remaining silent. They're taking in consideration 2022 CR 0841D. There's an affirmative finding of family violence and no contact with Alexander White and Kayla Connor. And we're back here because the court had an issue with 2022 CR 0841D. So have both parties had a chance to look into that case?
Yes, ma'am.
All right, so give me information.
And I can tell you, Judge, I know we're silent, so I'm just trying to speak about factual issues.
Mhm.
It is being taken into consideration in the sense that, I guess, two parts. Number one is that she has stipulated as part of stipulations to this, I believe, part of the indictment on the second case, so she's taking accountability for that portion. That's partly why. Number two is that two of the co-defendants, which is Kayla Connor and Brandon White, have taken responsibility for their part of the actions. I believe Brandon White actually went to prison because he's the main actor in that case. And then third, it was just, as you are aware, being a former prosecutor, it was made in consideration to prevent a child witness from having to testify unnecessarily when we have the same degree of offense for both cases.
All right.
And Your Honor, to speak to the case, I've spoken at length with Ms. White. I've really thought back over all the case, the other case that the court has been asking about.
Okay, you're whispering.
I'm sorry. I've had a chance to talk to Ms. White, and I really had a chance to look over the case and think about the questions that the court asks on this. I think the conversation I had with Kayla immediately after this past week, and we had a chance to kind of sit down and talk.
Voice up.
I'm sorry. I usually try to project.
Brenda, this is he's lowering his voice. You remember, I know people don't listen to the radio anymore, but they used to have secret storm or whatever, and people have the low voice. So if you could put it up here.
Right. You know, Jed, and I think it might be my allergies. I'm susceptible to mold, so my apologies if that's what it is.
Barry White had a low voice, but you could still hear everything he was saying.
Sometimes I try to pull it.
Okay.
Doesn't always work. But to continue, Judge, whenever our conversation was really telling, Kayla's very emotional in speaking about it, and she has been in the past. So the way just to lay out the facts of the situation, she was residing in this apartment, decent sized apartment with her husband. The COVID pandemic occurs, and Brandon White, who is the father of the child in the other case, implores them to allow him to move in there during the
Oh, no, I remember the facts of the case. I'm just trying to figure out honestly, the taken in consideration, which has been explained by the state.
Yes, Judge, and I'll be very brief. The way that in our conversations with the state and going through it, I think Michael is spot on. That Kayla's always been willing to take responsibility for any part that she played in any of this. I think it's very clear, and the way I've explained it, and this is me advocating for her as well. She's working as she does now, lengthy hours, and when she's home, most of the time she's sleeping. In talking to her, it's very clear in this case that Brandon White, the individual's, Alex's father, the child's father, essentially had the most interaction with the child. And he lives sort of a secretive life. I don't know if secretive is even the right word to put there. They lived their lives, and Kayla, to the degree that possible, continued to try to live hers. But when you talk to her about it, and I've related this to the state, that does she wish she was more perfect? Does she wish that she could have done, looking back on it, could have maybe done more or done those things? Yes, of course. I think everyone wishes they were perfect on things. But I truly believe, Your Honor, that she thought she was doing best, that she was trying to play her role, and that she trusted that that the child's parent, would be taking care of things in a responsible manner. Having a chance to look at the case in total, to look at Kayla White's role and everything and what could have been done, I do not believe that I personally do not believe that she is guilty of committing any abuse or violence toward Alex. But again, that's part of the conversation that we were having here, is that I think that when you look at the roles that were played here, Kayla White's role, while she will be the first to admit she could have done maybe more, was not the one that was resulting in the injury to the child. And so I think for those reasons, Judge.
I'm sorry, just one moment, that interruption. That was a medical call. All right.
May I proceed?
Yes.
And so looking at the case and looking at the situation with Ms. Connor, everything, the letters that I presented to the court last week, I think the picture that is painted is one that I believe of her that is within my sense of her, which is that she's always going to do her best. She wants to do her best, always. Will she make mistakes in life? Absolutely. But she's the type of person that will do whatever she can to make amends for those, to do better for herself, for her family, for her community. And I think that in the court's mercy, should she be provided and allowed to do a deferred adjudication, community supervision, the court will see that she will attend all of her appointments, do what is asked of her, not just the bare minimum, but beyond that. That's the person that I know her to be. And I think that's the reason why we're here today in this specific situation.
All right. Could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth? So help you God? All right. You're going to have to speak up.
Yes, ma'am.
All right. Could you state your name for the record?
Kayla Lynn White.
All right, where are you living?
I am currently living at 5711 Cuba Road in Seguin, Texas with my general manager and her mother.
All right, are there any children in that home?
No.
All right, where's your husband?
He's living with a friend as far as I know of. I don't know which friend and I don't know where.
Are you all still together?
We are still married.
But no, are you still together? Are you still in contact?
No.
What's his name?
Christopher White.
So is she asking that her probation be transferred to Seguin, or would she be staying in Bear County?
Either way is fine with me. If it's in
No.
San Antonio, I'll take it.
No, let's not do the either way.
It would be Seguin, Judge. I think about just knowing these things, I think it would probably be best.
So are you asking that your probation be transferred to Seguin?
Yes, Your Honor.
Probation, is that possible?
Your Honor, it won't be transferred from that account. It will still be supervised here.
Okay. All right, the court will follow your plea bargaining agreement. There's a $1,500 fine. That will be probated. 5 years deferred adjudication. Take in consideration 2022 CR 0841D. There's to be no contact with the following persons: Christopher White, Alexander White, Kayla Connor. There's to be proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. Defendant is not allowed to reside in any household with minors. There's to be no unsupervised contact with minors. There's an affirmative finding of family violence. There's to be regular reporting by Zoom or in person. If you're drug tested today, what are the results going to be?
Negative, except for my medications that I'm currently taking.
What medications?
It is a generic Lexapro. I can't pronounce it. It's Calipram or something like that. And I also take trazodone for sleeping, but I haven't taken it in a week because I haven't needed it. I've been too exhausted.
All right, what are you on those medications for?
Trazodone for sleeping because I have severe insomnia, and the generic Lexapro for my bipolar disorder.
All right. I'm going to ask for a MIC evaluation. And the defendant, you're going to have to sign a release so that the probation can have access to any of the medications and doctor's reports. There's to be regular UAs, field visits, 1 time per month, random. And that's until further notice. State, it's not listed in here. Are you all requesting any type of classes? Because there's not a BIP class listed or anger management.
I think it's because we were silent, Judge. We didn't make any.
Okay, thank you. All right, the BIPP course. All right, and State, I know you're silent, but now that you know there's the court is granting her application, is there any condition that you think will be helpful for her? Her?
Not that I could think of, Judge, other than Christopher White is a fugitive from his court.
Mhm.
So I hope that if she does not have that information, but if she does, that she pass that on to law enforcement so that he can be brought to court to face the charge. He's a co-defendant on this case.
Okay. All right. You realize you're not to have any contact with Christopher White. That means not by phone. That means Not in person, that means not by card, not by any type of signals. You understand? If you end up having contact with him, that's going to be a violation of your probation. A motion to revoke will be filed, and you could be looking up to 10 years in prison. Do you understand? Probation, is there anything else that she needs? Probation, is there anything else she needs?
No.
Is there anything else you need from the court in order to be successful?
No.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because there is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you. Remain in courtroom. Probation will go over conditions with you. Or as people say, catch a case. Conditions 1 and 1, the court could find it true, grant the motion, find you guilty, and sentence you up to life in prison and up to $10,000 fine. Court will find 1 and 1. Are you Ms. Smith? Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Keisha Smith who was placed on deferred adjudication in 2020 CR 9874B for the offense of aggravated robbery on February 25th, 2021 for a period of 5 years? Is that you? State?
Violated condition number 1, on or about the 30th day of September 2022 in Bexar County, Texas, the defendant Keisha Smith committed the offense of possession of a controlled substance in violation of condition number 1.
How do you plead, true or not true?
Violated condition number 1, on or about the 30th day of September 2022 in Bexar County, Texas, the defendant Keisha Smith committed the offense of theft in violation of condition number 1.
How do you plead to that, true or not true?
We've waived the remaining conditions.
Any objections?
No objection, Your Honor.
Conditions 1 and 1, the court could find it true, grant the motion, find you guilty, and sentence you up to life in prison and up to $10,000 fine.
Yes.
Knowing that, do you still wish to plead true to violation of conditions 1 and 1? Court will find 1 and 1 true. Is there an agreement?
There's not, Judge.
All right, state, what are you requesting?
Judge, in this particular case, the recommendation of probation was state ISF. However, in conferring with the defense, she doesn't believe she wants to wait in custody for state ISF. So I think in this particular situation, she's on for a very serious violent felony, and she's picked up new felonies now. At this point, if she's not willing to go get that treatment and she doesn't want to wait in court or wait in jail until she can go to state ISF, then we believe the only remedy that we have would be for her to go to prison, for her to be revoked and sentenced to 5 years tease.
Defense.
And Judge, she is willing to do state ISF. The only issue is she doesn't want to wait 5 months in custody because of the backlog. There are several defendants that have been told it's a 6-week wait. Don't worry about it. It'll be, over before you know it. And they sit months and months and months waiting for a bed. I've talked to the state. My client would be willing to report weekly if she needed to while she's waiting for a bed. She wants the treatment. I will call my client just to,
No, I mean, I'll take your proffer. If you want to call your client, you can. But the issue the court is having is that she's picked up 2 new felonies. And now people, are complaining about the wait.
Absolutely, Judge. And if I can may I call her?
Yes.
Ma'am, could you state your name?
You can raise your right hand. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Ms. Smith, do you realize how serious the case you're on probation for is?
I do.
Do you understand that, as the judge explained, when you're on probation for this type of case, if you're on deferred adjudication, you're subject to the full range of punishment for this kind of case?
Yeah.
And yet, somehow, some way, you've been arrested for shoplifting. Is that correct? And it's been twice that this has happened. And one of the times you were arrested, you were in possession of some drugs. And why are you out shoplifting?
Basically, I've been on the probation for almost 2 years, and I wasn't even arrested. I had a fallout with my parents, and I didn't have anyone to say. So when I, the only people that I knew was previous times. And when I relapsed and got back on drugs, if you could see, these cases all happened within a certain amount of time, and those were the times that I was usually arrested. Prior to that, I was perfectly fine if I was to be able to do like a sober living or get some type of support where I can't stay off of drugs. I know that I can be successful.
And let me ask you a question. How old are you right now?
I'm 35.
And at any point did you have a career?
Yeah, I do. I worked for a Wells Fargo Bank for 7 years before you began. I worked for a pharmaceutical company, CVS. I'm currently in college for cosmetology at Vogue, which can be confirmed through my probation, which is another reason why it's not that I don't feel like I deserve to wait. I understand that's better than when a person waiting for the bed for ISF because I do want to help, but I just really wanted to get back to school. And I know I should have thought about that before, but again, my mind wasn't where it should have been.
Okay, and let me ask you this. Have you tried looking for work while you've been on probation?
I was working while I was working.
Okay, have you encountered problems because of your felony probation?
Yes. The type of work that I'm used to is, it's a banking or where I tried to get back into the banking because of my record is it's honest. Like I get the job and then once the background comes, it's a little bit discouraging.
And you're on deferred adjudication probation. Do you understand that if you successfully complete it, you would not be convicted of the aggravated robbery? Do you understand that? And you understand that you could seek to seal your record. It would be an option that would be available to you.
Yeah.
And has that been part of your long-term plan to be a productive member of society, to get back to some normalcy?
Absolutely.
And do you have a drug problem? And are you trying to address that problem? You need to speak up, I'm sorry.
Yes.
And are you trying to address that problem?
Yeah.
And are you willing to go in addition, like state ISF?
Yeah.
Are you willing to do outpatient or NA meetings, AA meetings, that sort of thing?
Yeah.
And are you asking this court to consider that if she gives you a chance to continue on probation, are you willing to do whatever the court requires?
Yes. Absolutely. I also, what I've learned from relapsing is I was naive into thinking, oh, well, that was just a moment in my life. That's not me. I'm not a drug addict, or it was just a phase. But after relapsing, now I know, and I do take into consideration how serious addiction is, and that it is not something to take lightly. It's not ever going to be just a weekend party thing for me, or it's a lifelong battle that I'm going to have to face. So I do take it seriously. That's just something I have to manage from relapse.
And if the court wants you to do zero tolerance or to go to state ISF, will you take it seriously? Is there any point in you going?
Yeah, absolutely.
And all of this happened. Were you married at some point?
I am.
Okay. Are you still in that marriage?
I am, but we've been separated from you.
Okay. Why did you get divorced?
Infidelity on his part and abuse.
Okay. Are we talking about domestic violence? When you first got arrested for aggravated robbery, were you in a relationship with a gentleman that was involved in that?
Yes.
And was there domestic violence in that situation? Did he shoot you in the back of the head?
Yeah.
Is this an issue you've been dealing with?
Yeah.
Have you been in a relationship with a gentleman that was involved in the Walmart incident? Was there anybody there that was involved in that?
Yeah.
And is that a different person?
Yes.
So we're talking at least 3 people that you've been in a dating relationship that maybe haven't been the healthiest choice for you. And are you willing to keep counseling or do what it takes to not continue this repetitive cycle of self-destruction? Are you asking the judge to continue you on probation, extend you at additional conditions, whatever she feels is appropriate, if she decides to do that? Okay. I have no further questions.
Just very briefly, Judge. Ms. Smith, you were placed on deferred for an offense involving theft, correct?
Yes.
And now you're back before the same judge because you committed a theft again, correct?
Yes.
Where the probation officer on their report wrote that you had stopped working. Is that true?
I stopped working because they gave me permission to go to school full time.
But where were you previously working?
CVS, Caremark pharmacist.
What is Heart at Home Senior Care?
Oh, yes, I go part-time job there.
And what did you do there?
Take care of elderly people, getting their house clean, their clothes washed. But that didn't last long. Because my background came back.
And for good reason, right? We don't want people who have theft offenses caring for people like that, correct?
I've never stolen from a person. I do have a good heart. I wouldn't steal from people.
You were part of an offense where y'all stole from someone who was in a parking booth, correct? At gunpoint?
Yeah.
The aggravated robbery, who was the robbery of?
A flower shop?
Okay, but y'all were robbing someone for their property, correct?
Yeah.
Okay. And you did commit a robbery in this shoplifting case, correct? Or I'm sorry, a theft in the shoplifting case, correct?
Yes.
I'll pass it.
Were you using drugs at any point during these shoplifting incidents?
Yes.
Why were you shoplifting?
All right, so what altercation did you get into with your mom?
My mom is very disappointed in the decisions that I made.
No, that's not my question. My question is, why did you get into an altercation with your mother?
Because she wanted me to stay home and I needed to go. I needed to go fill out the information for school, and she didn't want me to go on that day. She lived far out where there's no bus line. So I needed her to drive me there, and she was on her way to work.
All right, so here's your choice. People cannot write their own programs. If people could write their own programs, we wouldn't be here because everybody would be doing fabulously. Everybody would write their own program. They wouldn't be using drugs. They wouldn't continue to use drugs. They wouldn't continue to use drugs and pick up cases. Or as people say, catch a case. That wouldn't happen. You have. So here's your choice. You can either remain at the Bexar County Jail and go to ISF, Cognitive and Substantive Abuse Track, or you can go to prison for 5 years. Those are your choices. Which do you choose? Not in charge of you for 2, for 1 or not, but this tells me where her mind is.
No.
No, I mean, it does tell me where your mind is. So do you want the 5 years in prison or do you want ISF? Yes or no? I'll deny the motion, alternate amend conditions to include ISF, Cognitive and Substantive Track, and probation. She is not allowed, and I want you to hear me when I say this, and I want you to internalize this. I don't allow people who are on probation out of this court to ever, and people say you should never say never or ever, but in this court, you are never, ever allowed to have employment as a home healthcare provider or any jobs that involve minors. Do you understand? And I don't know why CVS Pharmacy would allow you to be working for them when you have a drug issue. You shouldn't be working around anything that has to do with medications when you have a drug issue. You shouldn't be allowed to be working around any place that has anything to do with medications or drugs when you have a drug issue. So it's going to be ISF cognitive substantive tract. She's to remain in custody until transferred. No employment as a home healthcare provider or with minors. Is there anything else from either side?
No, you're.
All right, thank you.
In the end, the sentences tell the real story. 5 years, 10 years, treatment instead of prison, but only for those willing to earn it. The judge's message is clear. You don't get to write your own program. If you want help, you wait for it. If you don't, you go to prison. If this breakdown opened your eyes, hit like, drop your thoughts below, and subscribe for more real courtroom justice.